I wanted to discuss the economic impact analysis that occurs under the APA. As part of California's Administrative Procedure Act, the APA, executive branch agencies in this state adopt regulations, and they're required to conduct an economic impact analysis. So, what exactly is that analysis, and how have the courts in this state interpreted agency actions to comply with the statutory mandate to complete the economic impact analysis? Under existing law, all regulations are required to have an analysis of the potential economic impact of a regulation. Specifically, under Government Code Section 11346.3, a state entity proposes to adopt, amend, or repeal a regulation, and it must assess the potential for adverse economic impact on California business enterprises and individuals. And the executive branch rulemaking entities are required to avoid the imposition of unnecessary or unreasonable regulations or reporting, record keeping, or compliance requirements on business enterprises and individuals in California. Now, unfortunately, this short economic analysis is done by simply completing the EIS, the Economic Impact Statement, which is a 5-page sort of fill in the blanks form, which probably makes sense for the vast majority of regulations that are considered. And the executive branch state agency, prior to submitting its proposed rulemaking package to the Office of Administrative Law to begin the formal rulemaking process. In other words, it's part of the initial statement of reasons. That state agency or department has to consider the proposed regulations' impact on California businesses to compete with businesses in other states. And the state agency must even consider information that's been supplied to it by interested parties. So what does this economic assessment impact analysis include? Well, the state agency is required to assess whether and to what extent the proposed regulation will affect the creation or elimination of jobs within the state of California, the creation of new businesses or the elimination of existing businesses within the state of California, the expansion of businesses currently doing business in the state of California, and the benefits of the regulation to the health and welfare of California residents, as well as worker safety and the state's environment. Now, under the APA, the economic impact assessment of the proposed regulation has 3 phases according to the courts. First, the agency makes an initial provisional determination of whether the proposed regulation will have a significant adverse economic impact on businesses. The second phase is during the public comment period, affected parties may comment on the agency's initial determination and supply additional information relevant to deciding this issue. And then the third and final phase is when the agency issues its final decision and final statement of reasons, the FSOR. It must respond to those public comments and either change its proposal in response or explain why it hasn't done so. And this was set forth in the California Supreme Court case of Western States Petroleum Association versus the Board of Equalization that was issued by our High Court in 2013. In an appellate court decision in 2018, John R. Lawson, Rocket Oil Inc. versus the State Air Resources Board, the appellate court in California said, under the economic impact assessment requirement of the APA, a rulemaking agency making an initial disclosure must include facts, evidence, documents, or testimony in support on the initial determination that the regulatory action will not have a significant adverse economic impact on businesses. The APA broadly requires consideration of significant statewide adverse economic impacts that directly affect businesses. The APA also requires an analysis of several factors that are broadly drafted in a manner which does not suggest solely interstate impacts. And a state agency is not permitted under the APA to ignore evidence of potential impacts to specific segments of businesses who are already operating in California from benefits to other in-state businesses when proceeding under the APA. The Lawson Rock and Oil versus CARB case in 2018, the appellate court also said, in addition, if the agency's proposed regulatory amendments place the state's thumb on the scale for one group of in-house businesses over another, the agency needed to consider that impact. Moreover, in failing to properly respond to the comments regarding intrastate competition issues, the agency failed to abide by its obligations under the APA in either form or substance. In other cases, the courts have said that a regulation is not necessarily invalid under the APA, even if it has a significant adverse economic impact on business. Under the APA, the provision stating that if an agency makes an initial determination that the regulatory action will not have a significant statewide adverse economic impact that directly affects businesses, then the agency is required to make a declaration to that effect in their notice of proposed rulemaking action. In addition, in the appellate court case in 2011 called California Association of Medical Services Suppliers versus Maxwell Jolly, the Court of Appeal said the agency's determination does not need to be conclusive, and the agency need not assess or declare all adverse economic impacts anticipated. An agency's initial determination of the economic impact of a regulation under the APA calls for an evaluation based on facts. Mere speculative belief is not sufficient to support an agency declaration of its initial determination about the economic impact of a regulation under the APA, and the agency must provide in the record any facts, evidence, documents, testimony, or other evidence upon which the agency relied for its initial determination. So, as you've heard and can probably ascertain, the economic impact analysis is definitely an important part of a state agency's rulemaking activity, and the agency must duly consider the economic impact before taking final action on its proposed regulation.